unlawful detainer statute was enacted, it was incredibly speedy at that point in time. But the speed of our lives has accelerated since then, and now it's slow. And many other states have faster procedures than we have here in Arkansas. There's a filing fee for circuit court. Circuit court is the only court in Arkansas that can hear these. The district courts don't have jurisdiction to hear them. And so circuit court, there's a $165 filing fee. That is not counting additional court costs or attorney's fees. The pleadings are technical, and they're not really the kind of pleadings that you can write up for yourself unless you are an attorney. So whereas some states have streamlined procedures that allow landlords and tenants to represent themselves, that's not the case in Arkansas right now, unfortunately. And circuit court is slow. It may be weeks before you can get heard. I'm sure that Howard can give you more details on that. So what the Landlord-Tenant Study Commission came up with as a solution was a civil eviction statute where the landlord can file in district court for a $65 filing fee, put forms on the internet, as we have right now. We have forms for small claims court on the internet that are there for both landlords and tenants. Assume that landlords and tenants will appear pro se, that is representing themselves without an attorney, in district court. Now this raises a problem for landlords who are actually entities. What if you personally don't own the rental property? What if you put it in the name of an LLC? The law doesn't let corporations and entities represent themselves. The law says they have to hire an attorney. But a number of states have changed this, and I believe that we could too. It would take a rule from the Supreme Court or a statute and allow entities to appoint somebody to represent them. This already happens in other states. Allow tenants to raise counterclaims. So if they have legitimate issues with their landlords, let them have their day in court. And give them the right to appeal, give both sides the right to appeal to circuit court and a jury trial. There are no juries in district court right now, but give people the right to appeal to circuit court and a jury trial if they wish. So this was recommended by the Landlord-Tenant Study Commission. I predict that a bill with these provisions will be introduced in the 2017 session. So that's eviction. Let's move on to the implied warranty of habitability, aka a landlord's duty to repair. At common law, traditional law, landlords did not have a duty to repair. And beginning in the 1970s, courts started to hold that because residential landlord-tenant law was basically consumer law. Housing is a product. It's like buying a car. And tenants today aren't medieval tenants. They don't, go around with their cows and their bag of tools, and they don't build houses for themselves. They live in an apartment. Lots of times they don't know what to fix, how to fix what's going wrong. So beginning in the 70s, courts and then legislatures started to enact what we call today an implied warranty of habitability. And basically, this is just a covenant that the law will imply in every residential lease, it's not in commercial leases, that a landlord has a duty to repair premises. And this is a very basic duty. We're not talking about keeping the hot tub hot. We're talking about very basic, fit, habitable premises, and that's it. And this idea, after several decades, could be found in virtually every state. Alabama was the last state to adopt it in 2007. And now all states have it except for us. There's something else I wanted to say about it. Back to the history, can't remember now. So, what does it cover? In 2015, House Bill 1486 was introduced, and this was one of the narrower versions among the states of an implied warranty of habitability. I would not characterize this as a pro-tenant warranty warranty of habitability. It's a narrowly drafted implied warranty of habitability. It has a laundry list of things that the landlord is responsible for providing. It calls for a list at the beginning of the tenancy, listing any defects on the property or certifying that the property is habitable at the time the lease commences. If a repair is needed, the landlord has 14 days to repair. Does it cover everything? If I'm a tenant, can I go in and trash the premises and then complain that my landlord is not making repairs? No. It does not cover slight defects or defects caused by the tenant or anybody on the premises with the tenant's position or permission. And also, one concerns landlords. Everyone has the nightmare of a huge lawsuit against you in tort with a gigantic jury verdict. And so the bill specifically stated that tenants may not recover tort damages for any breach of an implied warranty of habitability. That is the current law in Arkansas, and the bill was specifically drafted to keep that as the law. On the other hand, landlords cannot require tenants to waive their rights to the implied warranty of habitability. So if you signed a lease saying that you were waiving your right, that provision would not be enforceable. If tenants exercise their rights under the implied warranty, they can't be evicted just for that reason. Remedies for breach. A tenant would have the ability, if they were being evicted, to raise this as a counterclaim. If the breach is serious enough, a tenant can terminate the lease, and then they can go somewhere else, but they have no more liability to the landlord. And theoretically, they can also get injunctive relief. A court could order the repairs to be made. Most other states have more remedies. In fact, over 30, and maybe even over 40 states, allow tenants to make deductions from their rent for repairs, for minimal amounts. That was intentionally left out of this bill to make it more enactable. I think that's the last slide. Yep, it is. I got really worried that I would have too many slides, so I started deleting them last night. So that bill didn't get out of committee. So here we are. I predict that it will be reintroduced in the next session. It was another version of this that was not as narrowly drafted was introduced in 2013. It didn't even get heard in committee. In 2015, it was heard in committee. It just didn't get out of committee. So maybe next time it could get out of committee. I would be happy. That would be my next milestone here in this process.
What is your view about why it didn't get out of committee?
Well, I'm going to let Howard answer that.
Members of the Realtors Association here? Anybody want to pass up their member of the Realtors Association? I'm going to go ahead and add a couple of points to 1486. First off, I see Greg Letting in the back, and I want to thank Greg for being our sponsor for that bill. 1486 was written by Lynn and me. That's a landlord and somebody. She says she's in favor of fairness, but she also represented, she brought the knowledge of other states together. We did draft it with an eye on making it passable, because if you look at the lobby structure in Arkansas, we had a big uphill climb against some very, very big money people. It was dead the minute it was filed. The realtors will say things like they did not agree to these landlord commission recommendations, but we've got the emails, and I watched their representative raise her hand yes every time. They will say they were never notified, but we've got emails where they were, just people got in the middle of it. And they had, in their mind, they had what they considered some objections about the wording of it. Certain phrases we used, they thought that the word safe was a wide open door to situations like in California where a judge can totally manipulate the law to get himself reelected. And they raised the fear, uncertainty, and doubt off of their groups. And the realtors are, gazillion times bigger than my group. And the bill at least got heard. It got a little bit of news play and was promptly flamed out.
Howard, I never had a chance to introduce you. Would you like that to happen?
Just start going to the next slide.
You wrote such a great introduction, that's a great little bio that I wouldn't want to deprive this audience of.
Go for it.
Okay, thank you. Arkansas native from Little Rock, bachelor's degree in computer science from Arkansas Tech, postgraduate work at the University of Arkansas. His graduate school professors quickly gauged his aptitude and immediately encouraged him to leave the world of academia. Because the problem of the business community. Howard is now works as a software architect for a Fortune 100 company, designs Medicare and Medicaid interface and medical fraud analysis software. And he's been involved in rentals, starting with deer camp and hunting rights leases, and moving into residential rentals. His business model is flip to rent, where he finds rundown properties, restores them, rents them, and then sells them often to the very tenants who rent from him. He's legislative director for the LandLords Association of Arkansas, was a member of this committee that Professor Foster was telling us about, a published author through the Amazon Kindle program, married for 25 years, shares his home office with an obnoxious cat, and has 3 grown children, none of whom want to be a landlord.
As you can tell, my first job in high school was working for a radio station, so I have a little bit of a flippant sense of humor, and Lynn has put up with me for a couple of years now, but so far she hasn't tried to kill me yet. When you look at the legislative scenario in Arkansas, it is us versus them. It's an adversarial process. Now, that's frequently a public stance. Up until this last group of elections, Arkansas also had a very pragmatic side to it. You would see party stances being taken, public stances being taken, but once the news cameras were turned off, people would talk, they'd work out their differences, and be passed. I see Senator Sue Madison here also, I believe, unless my eyesight is failing. I wear trifocals in case anybody's wondering. In 2012, we had the commission, and that was passed by James Ward at Pine Bluff. He was having a problem with some local landlords who really trashed downtown Pine Bluff, and he wanted something to be done about it. The commission was 10 people, 4 property management type people, 3 who would be considered to be pro-tenant, 3 who would be considered to be either academic or neutral in some fashion. And we were put in a room. We met once a month for a year on our own time and come up with ideas, come up with recommendations. And we did. We released a 38-page document. Every recommendation on it was voted unanimously. There was a quick letter sent afterwards called a letter for clarification, which was misunderstood. There's communication problems with that, and I'll take my share of blame for it. But it was meant to be just a letter of some clarification because people wouldn't read the 38-page document. They would assume something, and then the gossip chain would take control. The 2 biggest recommendations were what Lynn talked about, evictions and warranty. I'm going to go ahead and go and say, on the record, I was never a fan of the criminal eviction statute, but it's what's baked into the economy. It was a tool that was available to me, and I could price based on that. Warranty adaptability was more important to me because my daughter rented up here from a property manager that let the place fall apart and then tried to sue her to keep her in her lease. So that became a personal thing for me. During these sessions, what I learned more than anything else was to respect the opposite side. Yes, I've got stories of bad tenants. I've got my share of nightmare tenants who fall in love with the ex-husband, and he brings the pit bulls and the drugs back to my place, and when I have to evict him, he kicks it all the drywall, and he personally defecates on the floor in every room on the way out. That's not a lie. That's a true story. On the other hand, and I wish Marshall was here, Marshall would tell you about trailers where the floors fall through, the heat doesn't work, and it's snowing outside. And the landlord pockets the money, and the tenant won't complain because the tenant might not be fully documented. There's truth on both sides. And that was the most important thing that I came out of the commission was respecting everybody else. A point that was brought up a lot, and Lynn actually didn't bring it up, which surprised me. Lynn is on the Uniform Law Commission, which is a major, major thing to be proud of. It's a major accomplishment. And in her specialty, she works on the Uniform Residential Landlord-Tenant Act. You'll hear that a lot if you're attorneys. How many of you are attorneys? Fess up. Okay, we have one. There have been multiple attempts to run the URLT in Arkansas, but what happens is it's been run as an us versus them approach again. In our discussions, Lynn needs to be very proud of all the work she does on that, because she has to keep track of 50 states, and the way they take the uniform law and they customize it for their state, and that's what's always been missing when it's run in Arkansas. Customization. How is a landlord being notified if a repair is done? Does the tenant simply claim, well, I sent a smoke signal, I told my son to go put a note on his door or whatever, or do you do certified mail? Those little mechanisms and details are not there, and unfortunately in Pulaski County we've had experience of one circuit judge who absolutely despises landlords as a class of people. We did not want any law where a judge can pull an answer out of his rear end, and that becomes the method the whole state operates. And at the end of our commission, that's where Lynn and me and Marshall and a bunch of others said, what we ought to do is keep working together. Let's take the spirit of the URLTA, let's take pieces out of it, combine it, add the mechanisms the landlord wants, and get something that's passable. Get those protections in place. Well, in 2013, that's not what happened. Somebody took the URLTA out of a textbook, ran it, but the rumor mill took control, and some members of the commission got mad at other members of the commission because they assumed that somebody did something when somebody else really did it, and the communications broke down, and then finally we all calmed down, regrouped, and then we wrote 1486. And I'm proud of that bill. That's 2 years of my life, done on my own time, Lynn doing it on her own time, other people doing their own time to reach out into a consensus and in the middle and find something that would work for everybody. It was not perfect, but it's better. It was better than what we had, and it would affect the poorest people, the ones we're trying to protect. If you're a person of faith and you're saying you're here to protect the poor, then that bill is a place to work from. At least talk to us. Talk to us. Come to the table and talk to us. And that's what we still want. We're still going to keep reaching out. Because when you get us versus them, you get unintended consequences in bad legislation. And now let me show you why my little professors told me to go to the business world. Can everybody hear me okay? Yeah. Okay. See, my days up here were a long time before we ever had wonderful projectors and PowerPoint. So, here we go. I want to talk dollars and cents because, yes, I am a money-grubbing landlord. But I want to walk you through an example of what can happen with unintended consequences. I keep walking you through just a couple of quick points. I have for real a 3-bedroom, 1-bath house in Little Rock near LandLords. It's a good neighborhood, gentrified, mostly older people. Rents were $800 a month. Now, traditionally, you've got to plan that the house is going to be vacant between tenants. The house is going to have routine repairs. You're going to have to change a blower, the air conditioner, or patch a roof, or whatever. The industry standard for that is 25% of your gross income, assuming. So, my first state gross profit is $600 per month across a 12-month year. Now, after that, how many people are from Little Rock? How many people know Mayor Stotler? Okay, Mayor Stotler has to have his cut. So, Pulaski County property taxes, of course, they saw a good thing here during the real estate boom. So, property taxes was for a house for $100 a month. Then, I use traveler's insurance, but we've had storms, and you know, you cannot raise an individual person's insurance rates in Arkansas for having storm damage, but you can raise a whole county. My insurance, homeowners association fees, miscellaneous, etc., go up to another $100 a month. So this $800 a month house makes $400 a month. This is assuming it's paid for and there's no mortgage. 50% sounds pretty good, doesn't it? Now let's keep going. Let's talk about a real world case. Let's assume that January 1st I have to evict my tenant. Now my income coming in is $0, but I'm paying out $200 for taxes and insurance. Under the failure to vacate, we could get people out in 6 weeks normally. So we're going to go into February. We still lose another $200, so now it's a total of $400 we've lost. I've got to do some quick cleaning. We hope they haven't kicked in the walls. They might have. We're assuming it's just a peaceful, they've moved out. So March 1, not only have we lost February and January gross profit of $400, we paid $400 more here. That's $400 per month, by the way. So I'm down $1,200 net loss going into March 1st. But the house only makes $400. That means it will be April and May to zero me out. March, April, May, I zero out. That means I've lost 5 months. I mean, that at the end of 5 months of the year, the house is zero. That's a random number. It's 41% cut in my income. How many of you could take a 41% pay cut tomorrow for a month, for a few months? Now, I am no fan of criminal eviction. I'm not. But now let's add the costs for doing one. You have, on average, a $600 attorney fee for an experienced attorney who does evictions. $165 civil court process fee, $50 to $75 service fee, for a total of $870. So let's go back to February 11. I paid an attorney, so let's add another $875. We're down, $2,075. Now instead of 5 months to break even, it's 7 months to break even. That's the cost of an eviction. Now, I know it's boring money, right? Linda was saying, well, you need to bake that in. She's right, it does become a cost. How many of you work in retail? How many of you have never worked in retail? How many of you work for Walmart? Let's be honest about it. Okay, shrinkage, shoplifting, theft, roof collapses in a storm, and something's not covered by insurance, that money gets passed around. So now this house that makes $800 a month is down $2,000, $875 of which is because I had to hire an attorney to do an eviction. And again, I'm not saying I'm defending the criminal eviction statute. Where does that money come from? Do I tell my kids, I'm sorry, you can't go to summer camp, you can't have a bicycle, you can't eat? I have raised my rents. I have to cover that cost. And on a 9-month basis, because 25% of the time it'll be vacant, that means your rent goes up $100 a month. My $800 house just became $900. Now, let's pretend you're a married couple, Hispanic, legal. I don't even want to say whether you're legal or not. Let's say you're a married couple, you both work minimum wage jobs. You can, at $800, you qualify for that house based on 3 1/4 times income statistic. At $900, you don't. So suddenly you can't afford the rent. Or suddenly you're in a position where somebody gets sick and they have to take time off work, you're on the street. If you break it down by income, evictions hurt the lowest income the most. And if you're on the subsidized scale of it, the federal government issues statistics on how much they will pay. Little Rock, $800 is correct for a 3-bedroom house once you take utilities out. $900 is not. So you ask me as a landlord, okay, do I take the loss, or do I get rid of my Section 8 housing who need good housing the most, and I rent to 20-somethings who can pay the extra rent? Where does my market start going? What ends up happening because of unintended consequences, the people who need the help the most are now going to be hurt the most by this decision, because as a landlord, I don't have a streamlined method of getting possession. I don't want to punish the tenants unless they tear my place up. 2009, during the economic collapse, 100% of my tenants moved out in a 6-month period of time because they all got laid off from different employers. None of them work for the same company, but there's so much disruption. Every month I've got a vacancy, or 2 vacancies, or 3 vacancies, and I'm just scrambling to put tenants in and out. I don't want to punish them because they lost their job. I did my best to help them find places and find jobs. But they had to go, because I have to make those mortgage payments. And I want as a landlord, I need that streamlined possession that's available in Florida, and I don't know how many other states. Wow. I got bailed on, didn't I? We're there y'all are. Here we are. All right. And, you know, somewhere in my notes I've got Ben's research on how many states have a streamlined method, and that's what we want is, if I can get out of that $600 attorney cost, you just give me a form to fill out, did you pay your rent? And the district court, let the judge decide, does it need to be kicked up to circuit, or is it just a pretty clear-cut case about pay the rent? But that kind of effect doesn't happen overnight, but it is happening. Since January 20th, when Herbert White issued his decision, rents in Pulaski County range between 8 and 12% up. Most of my properties now are actually in a white-collar area. For various reasons, I've been selling off some houses. I wish I'd kept some of the low-income houses because they've shot up. Even the white-collar stuff, I'm renting 3-bedroom houses worth $13.95, and I'm getting it. I'm getting it from millennials because they want the neighborhoods. But what does that do to your low-income tenants? What does that do to people who are struggling on $7.50, $8.50 an hour? If you work for Walmart, you're going to get a pay raise. I'm going to commend the company for saying that, even though I haven't worked for it for 25 years. But, you know, if I was working for Bedford Cameron, you work in commission, what, you've got a slow month? What I can picture in the case of if you look at the cases of having 2 microphones on at one time, think about a warranty of habitability that could be written badly by one side. My ex-roommate from Arkansas Tech lives out in California, in San Francisco. His name's Sean Coons. I chose to stay here home in Arkansas because my family's all here. He had no family at all. He was a foster kid through DHS. So he went out and worked for this really unknown little company called Microsoft because they promised him stock options. I went to work for Walmart. I didn't get stock options. Then he went to work for a little company called Oracle. He got more stock options. Then in 2000, he retired at age 37 with way more money than I'll ever see. And he just decided to jump into being a landlord. He bought a 38-plex in San Francisco. First house. He didn't start out small. He jumped into a 38-plex. And he didn't research it either. The way the laws are in San Francisco, now he cannot get an eviction. That's not hyperbole. He cannot get an eviction. Because of their warranty laws, the way the city has drafted it, if he serves a paper, they go break a light fixture, the tenant goes and breaks a light fixture, calls code enforcement, I forget the legal term, they just throw the eviction case totally out, require him to fix a light fixture, then get it re-inspected, which could take 2 months. His method of eviction now is cash for keys. He will pay them to leave because the laws are so bad and so one-sided. And those are the scare stories we hear in Arkansas if you get that bad. I don't think it could get that bad very quickly, but you'll see people, like when we did our 1486, we were proud of that bill, but the stories about what that bill would enable were just way off of left field. And the fact of the matter is there's some high-dollar money involved. Think about Fayetteville area around the college. How many